Welcome back, guys. Advocates for Justice, Foreclosure Defense, Paralegal Service. We are different and we prove it. Hey, today we're going to talk about 5 things. Going to be strategies that you can use if you're in the middle of your fight right now. These are going to be things that you can use right away to help you get control of your foreclosure situation. So the first thing we're going to talk about is we're going to spend just a few minutes talking about what my conventional foreclosure defense strategy is all about. That's number one. Then we're going to talk about what you need to know if you agree to pay what they claim you owe, because there's a few things that you need to know before you even consider doing that. And third, we're going to talk about strategies you can use to fight your foreclosure outside of court. These are things that you can do to disqualify the lender and help yourself. And you can do this stuff outside of court. There's a lot of things you can do. You'll see. We're going to talk about those. Fourth, how to block the attorney from testifying in court, from speaking in court. Yeah, we have a plan for that, and it works pretty well. And number 5, last but not least, we're going to show you how to use the United States of America Affidavit of State Citizenship to challenge the court's jurisdiction in judicial foreclosures. And this would be a situation where they foreclose against you and you're in court answering to their stuff. Okay, that's where this will come in handy. So let's just jump right into it. So my non-conventional foreclosure defense program is set up to attack things that the conventional program does not address. People need to understand the conventional foreclosure defense program was actually set up by the same attorneys that's trying to steal your property. So when you go in using the conventional method, you're going to be in trouble because they structured that program to help them, not you. So you need to keep that in mind. So one of the first things we do when you enroll in our program is we teach you how to make sure that that person that signed their name on the document that started the foreclosure against your property is the number 1 defendant on your lawsuit, and then their law firm is the number 2 defendant, and the last servicer would be the 3rd defendant. That's all we use. We only use 3 people on there in most cases, because when you add all those other people, it just complicates the situation for you, because now all those people will start answering and you got to respond back to those people, and it just gets very complicated. At the end of the day, all those other people are not the ones that signed the document that they used to initiate the foreclosure against your property. What document are we talking about? In a judicial foreclosure, it would be the petition. Okay, if you check the petition to see who signed that petition, you'll see it was just the attorney. If you're in a non-judicial foreclosure, the document that you would need to check would be the notice of default letter, which is always signed by the attorney and not the trustee. So that means that the attorney is coming after you and not the lender, as noted in the lawsuit, which is a fatal flaw to their action. In a judicial situation, it would be a fatal flaw to their action. Once you add the attorney that signed to your lawsuit as the number 1 defendant, it creates a problem for the attorneys. So my job is to figure out the loopholes in the attorneys' processes, procedures, and their court strategies. And that's what I've done. So in this case, once you add the attorney to the lawsuit as the number 1 defendant and their law firm as the 2nd defendant, there's a problem that causes a problem for the attorneys. That causes a problem for the attorneys, because the attorneys can't litigate a case they're a party to. They can't represent themselves. So and there's a third thing that people don't realize. They also can't represent the corporation that they're affiliated with, because that would be considered pro se representation. And corporations cannot go into court pro se. They have to hire outside counsel. So now these attorneys are going to have to try to find some other law firm to represent them, because you're suing them for suing you. And most attorneys, when they're confronted with this situation, they'll realize that you know that you can add the new attorneys to the list also. It's ridiculous how these attorneys pass up on so many opportunities for people to get control of the situation just because of the way they do things, or just because they don't want to have the other attorneys get in trouble, or whatever it is that they do. They ignore a lot of stuff. Well, we're done doing that. So we're teaching people how to add the attorney as number one defendant and the law firm second. Now, when you add the law firm, okay, that blocks anybody from the law firm from stepping up to help out, because they would, they're included in this lawsuit. So that's one of the main things that we do in the non-conventional program. We want to make sure we're holding the right people accountable, and we want to do things that's going to cause them problems. That's what we do. So number 2, what you need to know before you agree to pay what they claim you owe. And this is very important, because a lot of people get themselves in a jam with this. They think, okay, the lender, if they'll take my, if I can just pay up what I owe, everything will be good. But that's not the way it works. Once you get behind, the lender is claiming that you violated the contract. Okay, so if you pay what you owe, the contract is still violated. Okay, they don't have to take your money and then put everything back the way it was. That's usually not the way it goes. What happens in most cases, if you agree to pay, they'll take your money, and then they'll have another attorney and they'll come after you and pick up right where the last attorney left off at. The whole time you're gone home thinking everything's fine because they accepted the payment. And then you find out later that your house has been sold. Yes, we have a lady in our Facebook group, Foreclosure Rescue, our private Facebook page. And when we first talked, I told her, if you decide you want to pay them what you owe, you have to make sure that they give you a new contract. Because if you just pay them, they will take the money and they will say you owe them that money from past payments and still come after you. And that's what they did to one of the ladies in our private Foreclosure Rescue Facebook. So what they did with her is she filed her lawsuit, but she didn't serve all the people, because she decided to go ahead and pay. She wanted to just pay and not have to worry about it. So she contacted attorneys, and they said, "Oh, sure, we'll." So they met with her. She paid the attorney, and she went home thinking that everything was cool. And she found out about 2.5 months later that her property had been sold. And the sad thing is, she found out her property was sold when they showed up at her house, when the crew showed up at her house to change the locks on the door and to empty the house out. So she called me freaked out. And what we did was, since she had already filed her lawsuit, it was on the record before the judge agreed to give the new buyer possession. So all she had to do was complete the service, and then she used the documents in the package to challenge jurisdiction of eviction court. And she moved the eviction process over to federal court to be connected to her title dispute, and everything worked beautifully. And once she did that, she motioned federal court to vacate the eviction process, and she also filed a restraining order to stop all that. And this was, if I remember correctly, it was several months before Christmas. And to date, she's still in her house in Texas. So the program that we put together after a lot of research and figuring out where the loopholes are in their program that we can use. And that was one of the big loopholes that we used. So she's still in her house, and that worked out pretty well. If you're going to pay what they claim you owe, you have to make sure that they give you a contract stating what you want to get out of it, whether you want to go back to making regular payments or whatever it is that you want to do, because that's kind of a slippery hill. And it's really sad to give away all your money that you could be used for fighting if they're not going to do things the way you need to have them done to make it worthwhile for you to go ahead and pay. So just keep that in mind. If you're thinking about paying, you need to make sure they give you a new contract saying they're going to accept your payment, put things back where they were, or things new or whatever, you just need to make sure that they can't continue with the foreclosure after they take all your money. Okay, I've seen that happen several times. Now, the fourth thing we're going to talk about is, and I like talking about this. We're going to give you some tips here on how to handle yourself in court. So what we're going to talk about now is how to block the attorney from testifying in court without a witness to provide jurisdiction to the court. And this is mainly for judicial foreclosures, or or even if you're in the eviction process. Well, hopefully, if you're in the eviction process, you've already executed the other documents that we have to protect yourself. That's the best way to handle the eviction process. But this situation is more for people that are in judicial foreclosure that are dragged into court with a lawsuit, with a petition, and all that stuff. So, in my opinion, the number one loophole problem with judicial foreclosures is that that petition that they serve you is signed by one person, and that would be the attorney that's actually doing the foreclosure, who is stating he's doing the foreclosure on behalf of the lender. But the lender never signs any of the paperwork. The lender never signs anything. You can check that petition. It's signed by one person, the attorney. And that's why we add that one person to the lawsuit as the number one defendant. But what you need to remember now is when you go to court in a hearing, okay, the reason they have those hearings is to feel you out and try and figure out where you're at. And if they can pull the wool over your face, if they can control you, they want to be able to control you in court. So when you go into court, the first thing you want to do when that attorney stands up and opens his or her mouth, the first thing you want to do is object. And when they get done laughing at you, okay, and ask why you're objecting, you want to tell them you're objecting because there's no witness. There's no witness before the court to provide the court with jurisdiction, and the attorney cannot testify. Anything coming out of the attorney's mouth is considered hearsay, third-party information. Attorney cannot testify in court. They get away with it all the time because no one says anything. But we're going to change that. So you jump up and object. You let the judge know that there's no witness in court to provide the court with jurisdiction. I would make sure the judge is aware that the attorney's testimony is third-party hearsay and cannot be admissible at trial. And if the judge is going to allow the attorney to testify on behalf of some plaintiff that's not here in court anywhere, then you need to demand that the judge swear the attorney in so you can cross-examine him or her. Anybody that's going to provide testimony before the court, you have a right to cross-examine them. There's no injured party in the court, so you need to cross-examine somebody. So that's what I would do. I would tell the judge, look, if you're going to allow the attorney's testimony to be on the record, then I'm going to demand that the court swear the attorney in so the attorney can testify under oath while I cross-examine him. Otherwise, this process is not fair for me, and the court would be obstructing the administration of justice. Yeah, that's the word that you need to use. Not violating your due process, okay? That's for criminal. In civil, it's obstructing the administration of justice. That's how you say that. Okay, so the last thing we want to talk about is the Affidavit of United States of America state citizenship. That document is pretty powerful, and people need to use it. You can use that document you can attach a copy of your birth certificate to that document, and you can use that document to challenge jurisdiction of court anytime you're the defendant that's dragged into court, okay? And the way you do that is, see, here's the deal. That document verifies that you are a state citizen of the republic state you were born in, okay? And people don't realize that there's two United States. There's the United States of America, which are all the states together, okay? And then there's Inc., the federal government. Now, the federal government has tricked us all into believing that we're citizens of the federal government, but nobody can be a citizen of the federal government because the federal government, nobody can be born in the federal government, therefore can be a citizen of the federal government because the federal government is a fake corporation. It's a fake entity, a fictitious entity. So nobody can be born in a fictitious entity. The whole thing is ridiculous. But that's how they get around everything. When you can verify that you're a state citizen of the republic state in which you were born in, you are no longer subject to the court's statutory jurisdiction unless there's an injured party. And what you do is when the United States of America Affidavit of State Citizenship, you can attach a copy of all of these things to it to verify your state citizenship, which means you're not subject to the court's statutory jurisdiction. And the people that are using that right now, one of the cases that are using it, and it's interesting, and we were kind of surprised, they took the affidavit of state citizenship and the passport and they sealed it so no one could see it, which was weird. And the attorneys were never able to argue the state citizenship issue, the jurisdiction issue, because of the state citizenship. They beat all around that and argued all this other stuff. You know, if they did not deny, they admit that the court doesn't have jurisdiction because of the homeowner state citizenship status. You want to put yourself in a position so if the court tries to move forward, now you have your appeal ready because they haven't verified jurisdiction. They haven't done anything. So once the judge makes any kind of a ruling, that's the way we do that. If you're ready to fight, head over to my website at winincourtnow.com, make your investment, and let's get started. Also, please leave me comments below about what you'd like to see me cover in my future videos. So down below in the comment section, just leave a little thing down there to let me know what it is you'd like to hear me talk about at the same time. There's a lot of different ways that we can, there's a lot of different strategies we can use to get control of your foreclosure if you're not doing the conventional program and following along with what they've set up for you to do, because that's not gonna help you. So anyway, thank you guys. I'll see you in the next video when we talk about the foreclosure process in South Carolina. And please like and share, and subscribe. Yeah, sometimes I forget about the third one. Subscribe, like, and share. Like, share, subscribe. Anyway, you guys know how to do all that stuff. Thank you. Have a great